Hi, my name's Sam Corse. I'm a legal executive in the Contentious Trusts and Estate team here at Whitehead, Monckton. Today I'm going to talk about beneficiary actions against trustees and the potential options open to beneficiaries where there may be concerns about the way a trustee is administering the trust, or there is ultimately a lack of anything being done, amongst many other things. This would of course apply to trustees of trusts, but also to perhaps administrators or executors of an administration of a deceased estate. Firstly, a beneficiary is entitled to request accounts from the trustees for the trust, and it's important that a trustee does keep accurate and very detailed accounts for the administration of the trust. A beneficiary may want to see these if there's concerns over how the trust is being administered, or they simply want to check how assets are perhaps being invested, or if there are real concerns over the administration of the trust, that all the assets can be accounted for within the trust itself. It's important trustees do this, as a beneficiary can ask for an ordinary account, or they can ask the court to issue an account on the basis that any loss suffered by the trust through any wrongdoing by the trustees or any costs taken are shown in the account that is then produced. There's been several cases where beneficiaries have had to go to the court to ask for accounts to be produced, perhaps where trustees have refused to do so. And there's also been cases whereby a court has found that trustees have not provided the accounts in a reasonable amount of time to the beneficiaries upon disclosure. So it's equally important for trustees to ensure that any requests for accounts are dealt with in a timely and an efficient manner. The next subject I'm going to discuss is a breach of trust or a breach of fiduciary duty. A breach of trust may be an act done by a trustee or a failure on their part to do something. A dishonest breach may come about as a result of the trustee knowing what they are doing is wrong, but that may not always be the case. Breach may come about through a trustee failing to comply with a requirement or the term of a trust, or a failure of them to give consideration to something they should have before making a decision. More often this comes as a result of pressure by beneficiaries on the trustees to do something, which can potentially lead them into doing something incorrect in terms of the administration of the trust and any decision made. It's important that the trustees check that they have the power to do what they're doing, they've given all consideration to the facts, and they need to check that they don't require consent of a particular person to consent to the decision that they're looking to make. If so, it could be that any distribution, for example, is void on that particular point. The more obvious breaches of trust relate to perhaps a trustee taking payment themselves from the trust or paying to a beneficiary that they shouldn't. In addition, there's also breach of fiduciary duty, and the two main aspects there in respect of trusts are a no profit rule in respect to the trustee, and they must not profit from their position as a trustee at the expense of a beneficiary. And there's also the self-dealing rule, and the trustee must not place themselves in a position of conflict in which their personal interests conflict with their duties as a trustee. This may involve buying the trust asset themselves or something of that kind and nature. If there is any breach of trust, then the trustees will be required to pay any assets back to the trust or make good any loss suffered by the trust. The next subject is setting aside a decision by a trustee. This is relatively brief in that if a trustee does make any distribution from the trust that either is incorrect or they haven't given consideration to a term of the trust, then the beneficiaries can apply for the decision made to be set aside. And the same principles apply, that a trustee may be liable to any loss suffered by the trust itself. And the final topic just to come on to is perhaps an application by a beneficiary to remove a trustee, or even in the context of an estate administration, the executor of or administrator of a deceased estate. The court's guidance on this point is a mere falling out between a trustee and a beneficiary isn't sufficient. There has to be a clear issue which will be detrimental to the administration of the trust or distribution of the trust were the present trustees to remain in place. So there may be significant delay in administering the estate, for example, or administering the trust, or complete lack of failure to do anything by any of the trustees or executors, which could justify the court in removing them and a replacement being appointed. So that's a very brief overview of actions available to beneficiaries, but one of the equal takeaways from this is the importance of trustees to take advice on their position, perhaps if they are under pressure by beneficiaries, because there's a range of options also available to trustees prior to making a decision. such as seeking directions from a court or blessing to any decision they make. But more importantly, it's important that they take professional advice in respect of the contents of the trust itself. But whether you're a trustee or whether you're a beneficiary and you are or can relate to any of these positions that I've spoken about today, then I would strongly recommend that you get in touch to take appropriate legal advice on the position. Thank you.